The sign said no stopping. I stopped. I'm guilty. The words land hard. The citation lists a red zone at school drop-off, a fine doubled by late fees. The prosecutor reads the statute. Safety corridor, strict liability, no exceptions. The judge looks only at the ticket, then at the mother. Name, Isabella Cruz. Plea? Guilty, Your Honor. No excuse. I was dropping my son. Prior violations? None. Employment? 2 shifts, retail and night cleaning. The prosecutor pushes the point. This zone is marked. Cars must keep moving. 6 minutes stationary creates danger. 6? Isabella blinks. I don't think it was 6. The judge raises a finger. Time will be addressed. For now, why the delay? Isabella swallows. I pulled up where I shouldn't. I knew it. I thought it would be quick. It wasn't. The judge turns to the officer's affidavit. The ticket is precise. Time of observation, plate, location, distance to hydrant. Photographs are referenced, not yet displayed. You admit the zone. You contest duration. I admit the zone, Isabella says, and I'm prepared to pay. She stops. Just what? I'm not here to dodge this. I'm here to keep my lights on while I do the right thing. The judge studies her. You accept responsibility. That helps. It does not erase the risk created. I understand. Did you move when told? There was no officer. I moved when I could. The prosecutor presses again. Late fees are statutory. Statutory, yes, the judge replies, but not mindless. He closes the folder. We will reconstruct the timeline. A low hush settles. The judge sets boundaries. No speeches, only facts. He will call the evidence in order. Officer notes, timestamps, any corroboration the defendant claims to have. Isabella's eyes flick to her purse like there's a truth inside it. Waiting. The judge nods once. We will see whether 6 minutes is 6 minutes or something else entirely. A beat of silence, then the gavel's gentle tap. The case has begun, the admission on record, the stakes unmistakable. And the room leans in for the clock that will decide the day. But what surfaced next pulled the courtroom into a sharper argument than anyone expected. Officer's log, the prosecutor says, placing the sheet forward, starts 7:41:12, ends 7:47:19. That's 6 minutes and 7 seconds. The judge scans. Photographs? 2 stills, time-stamped. They appear side by side, the same minivan, the same red curb, 2 different seconds frozen into certainty. Isabella clears her throat. I looked at the clock on my dash. 2, maybe 3 minutes. I pulled out when the line moved. Do you have a dash cam? No. Any witness? Not for the stop, Your Honor. The judge compares the stills again. Counsel, are these camera times synchronized with the officer's wrist log? Yes, Your Honor, the system syncs nightly. The judge nods and turns to Isabella. You said when the line moved. Why didn't it move? Cars were unloading in front. A child dropped a lunchbox. A driver opened a trunk. It just jammed. Did you activate hazard lights? Yes. You knew the zone? I did. The prosecutor stays on the statute. Hazards don't convert a red zone into legal parking. The law anticipates school chaos. That's why the rule exists. The judge sets the photos down. No one disputes the rule. We are measuring conduct inside it. Isabella opens her purse and presses her lips together, thinking whether to speak. She doesn't. Not yet. Any other documentation? The judge asks. Not for this part, she says softly. The judge reconstructs aloud. Arrival likely, 7:41. Queue stalled. Hazards on. Engine idling. The officer's vantage point from the corner. Photos taken at 2 points in the stall. Issuance at 7:47. Duration favors the citation, he says, but intent matters, limited only by safety. He looks at Isabella. If there is context that explains the stall, say it now. Otherwise, I will treat the time as established. Isabella holds the strap of her purse like it's the last steady thing in the room. There is context, she whispers. Then bring it. She nods once, breathes in, and decides to open the thing she hoped she wouldn't have to, The paperwork is heavy. The law is heavier. The judge is reaching for the scale. But the reason Isabella finally reveals turns weight into direction, and the courtroom pivots with it. My son started wheezing in the back, Isabella says. He was fine in the car, then he wasn't. I reached for the inhaler. The room stills. How long between the wheeze and the medication? The judge asks. Seconds. I had to check the spacer and count his breaths. Evidence, the prosecutor says gently. If we're going down that road. Isabella slides out a folded note. School nurse. He went in at 7:55. She wrote this because I asked her to. The judge reads, student presented with post-episode cough, albuterol administered at home. Monitoring recommended. He sets it aside. Pharmacy? Isabella places a small receipt on the rail. Picked up refills at 7:18. The time's on it. The prosecutor leans in. No one doubts a child's health. The sign still says no stopping. It does, Isabella replies. And I did. I chose to get him breathing again. The judge looks at the photos a third time. They do not show the back seat, the puffer, the breath that wouldn't come. Officer's observation is accurate, he says. It does not capture emergency. Your Honor, the prosecutor says, emergency exceptions are narrow. I am aware. I am also aware of proportionality. The judge shifts his questions. Ms. Cruz, what did you do after the inhaler? Waited for 5 breaths, listened for the whistle, asked if he could walk. He nodded. Then the line cleared and I moved. Why not pull around the corner? I was afraid to move him while wheezing. It's panic. You think small. You think air first. Prior episodes? 2 in the last year. I keep the inhaler for mornings like that. Clean driving history? Yes. Insurance current? Yes. The prosecutor exhales. We don't want parents punished for protecting kids. We do want red zones respected before a child is struck by a car. The judge nods. Both are true. He rests a palm on the file. The law hasn't softened. The room has. Guilt remains. So does urgency. Documented and real. The scale is moving, not to erase the violation, but to measure the lesson against the life it collided with. The bench goes quiet, the choice drawing itself like a line through the facts. And the next words from the judge make clear that mercy, if it comes, will not be cheap. Here is the balance, and the judge begins. Statute demands deterrence. Context argues for discretion. We will not confuse them. He reviews aloud. Marked safety zone, 6 minutes by record, hazards flashing, a child in respiratory distress, documented nurse note, active prescription filled that morning, a spotless driving record. Ms. Cruz accepted guilt without hedging, he says. That candor matters. The prosecutor proposes the schedule. Base fine and late fees. It's consistent. Consistent is not always just, the judge replies. Why were the fees late? Isabella answers plainly. Rent spiked. I paid gas to get to work instead. That's the truth. Ability to pay? I can pay a base fine across 2 weeks. The fees push me into next month's rent. The judge turns to options. A court may reduce or waive add-ons when circumstances justify a teaching outcome. I can also set a structured plan tied to compliance. Compliance, Isabella asks. Use the designated drop lane. If it's full, loop. No red zone. No hazard lights as permission. Understood? Yes. The prosecutor concedes a path. If the court insists on leniency, we ask that the lesson be explicit. The red curb is there so kids live to see third period. It will be explicit, the judge says. He looks at Isabella again. When traffic boxed you in, you decided to stay. Many people do. The difference is what you did with those minutes. You treated your child's airway. You did not weaponize your fear into anger at others. You did not lie here. The bench leans forward. Here is my offer. Reduced base fine, late fees waived, payment within 14 days. In exchange, you will sign acknowledgement of the rule and return proof of on-time payment. One miss and the full penalty reinstates. Isabella nods, eyes wet but steady. I accept. The judge lifts the gavel but does not drop it. One more thing. This is not favoritism. It is calibrated accountability. If you are back here on the same charge, none of today survives. A breath holds across the room. The outcome is close enough to touch. But the final ruling carries a condition that tightens every shoulder in the courtroom. Guilty as charged, the judge says. Violation stands. Base fine reduced to a payable sum. Late fees waived. A beat, then the condition. Payment within 14 days. Proof filed with the clerk. Violate the drop-off rule again within 6 months, and this order converts to the original penalty plus fees. The prosecutor adds the public lesson. Parents, hear this. Red zones guard tiny lives. Use the lane, circle the block. Don't gamble with seconds. The judge nods. Exactly. He turns back to Isabella. You chose air over asphalt math? I respect that. Next time, choose a legal space before the emergency arrives. Plan 5 extra minutes. If the lane is clogged, loop. Safety first and lawful. I will, she says. Clean record noted. Honesty credited. Obligation clear. Thank you, Your Honor. The clerk offers the acknowledgement form. Isabella signs. The pen shakes a little, then steadies. She looks up, not relieved so much as recalibrated. The judge closes the file. Court's purpose is not to humiliate, it is to correct. Today we correct with a bill you can pay and a lesson you must keep. He finally taps the gavel. The room releases a breath. The outcome is not flashy. It's precise. The law kept its spine. Mercy kept its edge. The mother leaves with a smaller fine and a bigger promise. At the door, she glances back once. At the red curb photo, still on the rail, a warning frozen in ink. She puts the paper in her purse beside the pharmacy receipt and walks out into a morning that suddenly feels navigable. Justice held the line, and a parent learned how not to cross it again. But the next case waiting on that docket would test whether candor alone could ever outweigh recklessness.